Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson. And let me introduce you to our guest panelists for today. We have Mr. Andre Wong, who's the General Counsel and Director of Public Affairs and Religious Liberty for the North Pacific Union Conference of the Seventh-day Adventist Church. We have Mr. Todd McFarland, who's the Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. We have Dr. Timothy Golden, Professor of Philosophy at Walla Walla University. And we have Mr. Lawrence Brown, who's the Associate Public Affairs and Religious Liberty Director for the Northeastern Conference of the Seventh-day Adventist Church. Gentlemen, great having you here with us and looking forward to our conversation today. You know, the right to silence is really a concept that's undergirded by the First Amendment protection that compels individuals to engage in conversations, but also protects you from engaging in certain conversations. For example, the law gives you an opportunity not to engage in self-incrimination. You've got testimonial privileges that exist between spouses and privileges that exist between clergy. You know, many of us think about this whole concept of silence only as it relates to criminal activities, where you always hear you have the right to remain silent. However, this particular idea is also a concept that kind of undergirds the Establishment Clause. It allows you to be in a position where you do not have to fight a government who should be, quote unquote, going out and making sure that it protects your religion, but they shouldn't also be establishing any religion. But it also protects individuals who have the right not to be engaged in religion in any way. You know, Dr. Golden, could you tell us a little bit about this concept? It seems like this is something that the courts have dealt with, but sometimes we as just individuals who are out there in the regular mainstream kind of look at this only from a single perspective, but there is actually this protection as relates to the Establishment Clause. Can you give us a little color on that?
Well, I think it's important to remember that the right to silence, as you're talking about it here, as part of this discussion, is really an integral part of what political philosophers call political liberalism. It's this idea that we are each individuals, that we each have certain rights, and that undergirding those rights is a metaphysical or philosophical concept of human freedom that enables us to have the right to not only speak, but to refrain from speaking. So it's a sort of concept that undergirds everything that we know to be valuable in the Western political tradition. In terms of the Establishment Clause, there's always been an inherent antagonism between the Free Exercise Clause and the Establishment Clause. In other words, how does a government, on one hand, allow for people to freely exercise their religious beliefs without endorsing any particular religion on the other? And so the right of silence is one of those things that without it, the religion clauses wouldn't really be what they are. They wouldn't really be what they've come to be. And so it's important for us to appreciate the nature of this right, because when we do, it helps us see that, as you pointed out, it not only applies in criminal cases with, of course, the right to remain silent, but it applies in free speech. And of course, here we're talking about it in the context of religion. So from a philosophical standpoint, it is one of those foundational rights that if we don't think about it carefully, we will easily take for granted.
You know, Todd, you're one of the guys that's out on the front lines fighting these type of battles. And one of the things that I always hear that you get the pushback from is individuals saying, well, they didn't really tell us a lot about what they believe, or we really don't understand what they believe. Why should we be in a position where we have to justify or protect individuals' rights when it's unclear, they don't talk about it, we don't see it? You know, what's the problem with that type of analysis, in particular from an employer standpoint?
Well, again, in an employment context, people do have the right to, to practice their faith. I think we're talking about a little bit more sort of where that is at. I mean, you do have to tell the employer what the religious belief is, and the employer is entitled, if you're asking for accommodation, to get enough information to determine its sincerity and understand the conflict between the work rule and the speech. There's a high level of deference given when a person asks for religious accommodation, but they don't have just to take it completely at face value. I think, picking up what Tim said, another context that we talk about this is a compelled speech, right? When the government tries to make someone say stuff. And that happens from time to time. For instance, the most recent set of cases been the Supreme Court was where states tried to get pregnancy crisis centers to give certain compelled speech about the services they offer and the services they don't offer. State of California has anyone who's been there knows that there's all these signs all over that, toxins known to cause cancer in the state of California are in this building, right? You got those signs up, and anyone who's been to California has seen those. So these are all examples of when the government has tried to make businesses and organizations and people can say things. Sometimes that's held been constitutional, other times it hasn't.
We know, Andre, out there on the West Coast, this whole concept of being compelled to speak, it seems as though we're not even seeing this being, quote unquote, judged the same way all the way across America. I'm assuming that we're going to get to a point where everyone is clear on the fact that you can't be compelled, but it seems like we had a lot of different courts coming up with different concepts, and even local laws sometimes make it a little confusion. What's been going on your side of the globe?
Yeah, it reminds me of these Instagram lawyers that post legal advice videos on social media. If you encounter law enforcement, don't say anything. One of them even says, "What do you do when police ask you questions? You shut the blank up." And it's easy legal advice because, while your words can be used against you, what cannot be used against you is your silence. Silence is not considered an affirmative act. The right to silence or the right of silence is based on individual privacy rights and the right against self-incrimination. So anyone that invokes their Fifth Amendment privilege against self-incrimination, the right to remain silent, that act cannot be used as evidence of culpability. And so not only in the criminal sense, but then in business, in contract law, when an offer is made by one party to another party to enter into a contract, one thing that never constitutes acceptance of an offer is silence. So acceptance of an offer to enter into an agreement requires an affirmative act of verbal acceptance. I accept your offer, or contract performance. So the privilege of silence is sacrosanct. Both not only just in the criminal context, but in the civil context, and in our discussion, the right to conscience.
But Lawrence, sometimes this must go too far. I mean, you get to a point where sometimes people expect you to actually espouse certain things that, if you've got nothing to hide, why not speak up? Why do you want to be quiet if it turns out that you're probably on the right side of things? I mean, how do you see this coming together?
Well, I want to point out that in certain settings, there's actually a mandate to not speak about certain things. I have a loved one who works for the federal government. And politics is a topic not up for discussion. But bottom line is this. When I look and listen to a lot of the foolishness being espoused and talked about, especially by some of the talking heads out there today, I sit back and say to myself, boy, I wish that person would exercise the right to remain silent right now.
Well, Dr. Golden, just tell me this, though. When does this go too far? I mean, do we get to a point where we really should be having people be more, quote unquote, verbal or more outspoken? Or is it really one of those things that's really a two-edged sword that sometimes, being quiet and not letting them know for sure that you don't know what you're talking about may still be the better cause of action?
Well, I think, Orland, it's interesting. It's an interesting concept you raised. You used the word should be. Everything that is moral or normative cannot be compelled legally. We would like to see people stop to render aid to strangers in need. And we've seen attempts to compel people to do that with things that we've called Good Samaritan laws. But those things don't work out too well. The fact of the matter is the law is the law and morality is morality. And what should happen morally can't necessarily be compelled legally. So I think we have to walk a fine line there and understand that the law sort of presents the world as it is. And in terms of morality, it's up to us to do or not do whatever we can to change the world or make the world better or worse if we decide to, and then the law will respond accordingly. But I think it would be a mistake to sort of compel people to speak messages or to present ideas that they may find objectionable.
So, Todd, you agree with that? This whole idea that maybe you can't compel people, for example, to do the right thing, the Good Samaritan rules? I mean, I know we don't want to actually put ourselves in a position where we're judging morality, from a government perspective. But, what about the whole concept that we should all be required to just do the right thing? And sometimes you got to, see something, say something. I mean, is that gone a little too far?
Yeah, again, Good Samaritan laws haven't, I think as Tim said, haven't really gone very far. I think there becomes a lot of very practical problems there. And I do think under most circumstances, people do the right thing. I mean, there's the famous case in New York about Kitty Genovese, I think I'm getting that right, where a bunch of people had, she was being assaulted in a courtyard and people didn't call. When you start nailing into the details there and what was going on, again, not defending the people, but let's just say that all of the Good Samaritan laws that existed, no one would have been prosecuted underneath those. It was a complicated set of events. And I do think that in most circumstances, people do the right thing, and it's not a problem that really needs to be solved with legislation or would be solved with legislation.
Andre, you agree with that?
Yeah, so one of the things that I talk about in my business law class that I teach is that there is no duty to rescue. There's no legal obligation to come to render someone else's to come to someone else's aid. And so it's when I discuss it with my students, it's so counterintuitive that if we see somebody in distress, whether you are a bystander or a medical professional, there is no legal duty to render assistance. So the clarification that needs to be made is Good Samaritan laws is a law that clears liability for somebody who does render aid. So if you do jump into a situation to, let's say, render CPR on somebody and you break sternum and ribs, you cannot be held liable for rendering aid and rescue. And so that's what Good Samaritan laws are about. It's not about the obligation to jump to rescue.
Well, let me ask you this, Lawrence. There's some people that think maybe there should be an obligation for you to step up and to say something on behalf of your fellow employees. If you know someone has an issue, for example, from a religious perspective, and you've been a part of their, circle of some sort, is it so far-fetched that maybe if you hear it, that you should say, we should be supporting people's practices? Or should it be, let me stay away from that because that's one of those untouchable subjects?
Well, listen, advocacy is my middle name. So, for me, stepping up and speaking up is just a natural reaction. However, it does get problematic when you want to assert that everyone now has a mandate to stand up, step up, and speak at given moments. Not only is it problematic, but it perhaps creates more problems than it solves. So I think for the folks who are willing to do it, we pretty much have to leave it there.
Well, I'm going to let that be the last word on this, but we appreciate all the information you've given us to really think about this concept as it relates to really our right to silence. There's an interesting case that came up in 2016, and it was a case called Dalberiste that was versus GLE Associates. This was one of those first cases that we had started hearing about in recent times that were dealing with the idea of one having a Sabbath in which they basically use that as a religious practice, and it was important that they would allow their Sabbath to be protected from a work standpoint. We have Mr. Dalberiste, who was somebody who was an environmental technician, and he was somebody who was engaged in a lot of different activities, but wanted to ensure that he could worship his God the way that he saw fit. This case ended up going to only what I would call the secondary levels of court cases, but it was really kind of beginning of really what I see as being an ongoing, maybe 5 or 6 or even 7-year fight regarding how do we deal with the concepts of protecting individuals. Another interesting concept, though, is the concept of Sabbatourism, or the concept of Sabbath protection, is something that really doesn't just revolve around Friday night sundown and Sabbath sundown, how some religions, for example, the Seventh-day Adventist Church and the Jewish religion may view it, but it really revolves around any accommodation regardless of what day of the week that you would serve your God in the way that you see fit. The court ended up ruling for GLE Associates. And one of the reasons people talk about that there is this rule that kind of been said in Hardison that we've been seeing religious advocates pushing back on for quite some time. And this was one of the ones where the Supremes decided they weren't going to get involved. But it turns out that this is maybe the first step of where we will start to see some real activity happening in the very, very near future. But, Lawrence, tell us a little bit about that case, the protection of the Sabbath and the protection of people who want to be off on Sunday and other religions that want to be off on Thursdays or Fridays. What exactly were we fighting for here, and where do we might be seeing this thing going in the future?
Right. So this is an area that's of great interest to me because it was my entrance ramp to the ministry of religious liberty in the first place. And the bottom line is this: you never want a situation where somebody is compelled to choose between faithfulness to God and being able to feed their families. In this case, like so many others that have come before, essentially pit an employee against his employer, who the employee was simply trying to ensure that he would not be put in a situation where he was forced to make that decision, and was even willing to bend over backwards to accommodate the employer in other areas, working Sundays, working late, working holidays. He wanted to show a good faith effort at getting this resolved. As has so often been the case, many times employers have a flawed basis upon which they want to argue that a person should not be allowed to be guaranteed this accommodation. And by the way, being from New York, can I just brag for a moment that when it comes to handling religious accommodation matters, New York is still the gold standard. And I'm happy about that. And I'm still hoping that one day on the federal level, the approach to how religious accommodation is handled will mirror what happens here in New York, because it's very fair and it's very balanced, and it puts people in a situation where, for the most part, if you can accommodate somebody without blowing up your whole universe, then you're compelled to do so. But Hardison is a case that for a long time I've been praying something would come up to challenge it. We thought this particular case that we're talking about now might have been it. Unfortunately, the court decided not to take it up, but hope springs eternal.
Todd, you had your fingerprints a little bit on this matter when it was being dealt with back in 2016. When you think about juxtaposing this against Hardison, what has really Hardison been the problem in making it very difficult for these type of cases to just be almost slam dunk as it relates to what many of us think should be happening in the area of religious freedom?
Sure. So just for those who don't practice in this area, maybe we just reflect what TWA versus Hardison is. It's a case from the late 1970s in which a gentleman, Mr. Hardison, brought a case against the airline TWA because he had moved shops and needed his Sabbath off. He wasn't Seventh-day Adventist. He was, I think, Worldwide Church of God, which also kept a Saturday Sabbath. And the issue in that case really was about the collective bargaining agreement. There was a union involved there, and there was problems with giving him Sabbath off and how that would conflict with the collective bargaining agreement. And so that's where all the argument was, that's where the briefing was, that's where the discussion was. However, the court in the case, really as an aside, said, well, anything more than what's known as de minimis or minimal hardship would be an undue hardship. And it wasn't what was argued in the case, it wasn't what was briefed, and nor did the court really decide it, or discuss it, I should say. They certainly decided, but they didn't really discuss what that meant. And that case was latched onto then by the courts of appeals and has been held really to hold, depending on how the court feels about the case, has really just been, can almost always find a minimal hardship if you want to. Now, people of faith have been able to prevail, and our office has been able to get very good outcomes from some members. But it really is up to the luck of the draw of the judge you get, also, quite frankly, how skilled the defendant was, their counsel, and how they did sort of during the process. So, we are hopeful that the Supreme Court, they have taken a case, well, they didn't take this one, they have taken a subsequent case called Groff versus DeJoy that's supposed to be argued in April and decision by June here in 2023. And so we're really hopeful that that case will be the one to set aside the Hardison standard and come up with a new standard that is, we're hopeful, either at the same level of or higher than disability. So disability, you have an obligation to accommodate people under the Americans with Disabilities Act. And so we're hoping the Supreme Court will adopt either that standard or even potentially a higher one.
You know, but Dr. Golden, it seems like Hardison has been around since the 70s. And as Todd has just mentioned, there have been a lot of matters that have been fairly successful in protecting individuals. What is it about Hardison that seems to be in the craw of most individuals that practice in this area when it seems as though many groups still seem to be successful with it?
Well, I think for that, you have to go to Justice Thurgood Marshall's dissenting opinion in Hardison. He was highly critical in that case of the fact that there seemed to be no real standard at all. And if I could just piggyback on some of Todd's commentary a moment ago, wouldn't we all feel better if Sabbath accommodation cases didn't come down to how the judge feels about the case or how crafty the other side's lawyers were? Wouldn't it be good if we lived in a world where there was a clear presentation of at least a clarification, I should say, of Hardison? Perhaps not overruling it, but perhaps giving us some sense of what it means, giving us a workable standard, which seems to be elusive. Now, again, as Todd said, he's right. We've still been able to get very good outcomes for people, despite the sort of frail standard of Hardison. But I think Justice Marshall's concerns, as he expressed them in his dissent in Hardison, are the sorts of things that ring true for advocates like Todd and many others who are trying to make sure that the congressional policy judgment, as Dr. Brown said, that a person should not have to choose between their conscience and their livelihood, is given some real teeth. And I hope that sometime soon the court takes up Hardison in the interest of making sure that this, at a very minimum, that this clarification is in fact made so that litigants and others know exactly what it is employers are supposed to do.
I just wanted to point out that that's why New York standard is so compelling, because in New York, you are not allowed to get away with any old trivial reason for why you don't want to accommodate somebody. New York essentially is asking the employer to bend over backwards to demonstrate that they went above and beyond to try and figure out how to accommodate a person. And to me, that is the more reasonable way forward, as opposed to just any old sorry reason why we can't do it.
Yeah, but Andre, bending over backwards, is that where we want to see employers nowadays? I mean, why shouldn't employers be in a position where they get to stand upright and just make some decisions and hopefully take some type of, positive reasoning for what's going on? But is bending over backwards really where we want to go with that?
Yeah, in the words of Ronald Reagan, there you go again. The Supreme Court's jurisprudence on this, on the workplace, on the employer, and the issue of religious observance, right to conscience, especially in Sabbath keeping, should not just be a well-beaten path at this point, but a nicely paved 4-lane highway. But if you look at it, it's still just a path. You go back to Sherbert v. Werner in 63, which kind of started creation of the construction of the highway. Then you have Hardison in 77. Thornton case and the Ansonia v. Philbrook cases in 86, actually the whole line of cases in the 80s, that created this patchwork of jurisprudence when it comes to the right to conscious Sabbath keeping and religious accommodation. It's a well-beaten path, but it's still just that, a path. And so now we have Groff coming up before the Supremes this term, which I believe is a very straightforward case in both facts and law, and hopefully they can get to building that 4-lane highway with Groff.
Orland, if I could just interject here, I want to add one more layer to the story that Andrew sort of just told. One of the things that's interesting is that Sherbert was decided the way it was decided precisely because you had a state, you had the state of South Carolina involved. Until President Johnson signs the Civil Rights Act of 1964, there essentially was no protection for private employees in the workplace, wow. Right? So when we talk about Title VII cases and we talk about cases like Hardison and others that are crafting judicial interpretations of it, it's an important part of this story to know that the pressure that was put on Congress in 1963 and 1964 that led to the Civil Rights Act is an important part of the story that we're all a part of today.
So Todd, today I'm going to appoint you to the Supreme Court. And now that I've appointed you to the Supreme Court and you get a chance to craft an opinion that deals with Hardison, what are the components that you would like to lay out that you'd like to see going forward?
Well, I think first the standard on the employer has to be higher. I think it needs to be at least at the Americans with Disability Act standard, which is significant difficulty or hardship. There's a 4-part test there that looks, what's a significant difficulty or hardship is one thing for a smaller employer versus a large national employer, like say the post office. So I think that needs to be an element. I also think they need to address the impact on third parties or fellow employees. And that is one of the questions that's up before them. Because employers, there's some that have said, well, this can never impact fellow employees. The challenge with that is almost everything is going to have an impact, right? Work expects to get done, and no one's saying the employer, the post office has to quit delivering in Groff's case on Sunday or in other cases on Saturday or whenever. No one says the employer has to get done. There's always a give and take in the workplace, and so I think they need to draw that line in a way that acknowledges fellow employees' legitimate interest in certain respects, but doesn't give them a heckler veto, and also understands that employees are there for a reason to get to work, right? And so, asking another employee to work and get paid for it is not unreasonable. And the employer under Ansoniak gets to choose the accommodation. And so they can do one, I think, that evens out the workload so no one's feeling overburdened.
Well, great. I think that's a great summation, Todd. And obviously, before we leave the show, I have to revoke your position on the Supremes. but I think that's a good way for us to kind of wrap up this segment. Andre, tell me something I don't know.
After the landmark decision, Miranda v. Arizona, Ernesto Miranda sold autographed Miranda warning cards for $1.50 each. Then in 1976, Mr. Miranda was stabbed in a bar fight in downtown Phoenix. The suspect who supplied the knife in that incident was never charged because he invoked his Miranda rights and refused to talk to the police.
My goodness. Lawrence, tell me something I don't know.
Well, beloved, this one is on a personal note. I just finished a 1-year anniversary at an assignment that has me happy as I don't know what. I'm enjoying it. I'm loving it. They're loving me. So all is right with the world.
Well, make sure they're really loving you. Todd, tell me something I don't know.
Despite what one of my panelists said earlier, there are circumstances in which your silence can be used against you in the criminal context. I commit to you Salinas versus Texas, 570 U.S. 178, before you start being quiet to the cops.
Dr. Golden, I'm not sure if that was you, but tell me something I don't know.
Well, despite the poignant remembrance of Bloody Sunday earlier this week, I think that another year will come and go without any movement on the John Lewis Voting Rights Advancement Act, introduced in the Senate by Senator Leahy and seems to be DOA. And it's a sad, sad thing to say, but I don't think there's going to be any movement on it this year either.
Well, gentlemen, just want to thank you for that great conversation today and looking forward to doing this again soon. Thanks again for being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.